I seek your Lordship's indulgence in mentioning part 2, item number 1. If this may be kindly taken up on Friday, my lord. I have taken consent. This is a jail appeal.
Huh?
Jail appeal. Part 2, item number 1.
No adjournment. Always adjournment.
On Friday, my lord.
No. We'll take it up together today.
My lord.
May I please your Lordship? Lordship, I beg to mention item number 2 of daily list. As my senior Mr. S.K. Mehdi has some personal difficulty on today. If possible, Lordship, on 27th of March.
27th?
Yes, Lordship.
Okay. Where is he? What is the problem?
He has some family engagement, some personal difficulty.
Right. On the prayer for adjournment made on behalf of Mr. S.K. Mehdi, list the matter on Friday.
Deeply held.
For admission, item number 1.
My lord, I have taken steps upon the respondents. And office note dated 16/03/2026 indicates that ID card for service has been returned and maintained by the registry, my lord.
My lord, I will be filing my...
Just a minute. Please wait. Let us see the award. Which page?
Arbitral award is at page number from 38 to 49, my lord. The operative portion is from page 47. Page 47, paragraph 9.1. Paragraph 9.1, page 47.
Yes, so what is your grievance?
My lord, my grounds are from page number 15.
No, what is your grievance? Don't say the page. Tell me what is your grievance.
My lord, my main grievance is that the award has been passed without the authority of the law, in as much as, my lord, I have clearly stated before in the arbitral proceedings that I have a clear objection to the claim of the instant respondent number 1. However, the learned arbitrator had recorded that the counsel
You mean the Arbitration Act.
my lord.
You are challenging an award on what basis? What is the ground of challenge? Come to section 34 of the Arbitration Act.
My lord.
What are the grounds under which you can challenge an award?
My lord, I have a very limited grounds, my lord, under
Yes.
section 31.
31?
Under section 34, my lord.
Yes.
Yes. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Now, subsection 2 reads, arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that a party was under some incapacity, or the arbitration agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law for the time being in force, or the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to represent his case, or number 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decisions on matters not submitted to arbitration may be set aside, or the composition of the arbitral tribunal or the arbitral proceeding was not in accordance with the agreement of the parties unless such agreement was in conflict with the provisions of this part from which the parties cannot derogate, or failing such agreement was not in accordance with this part, or B, the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, or the arbitral award is in conflict with the public policy of India.
So it comes under what? Your appeal comes under which provision?
My lord, it comes under Roman 4. The arbitral award deals with the dispute not contemplated by or not falling within the terms of the submission to arbitration. My lord, my submission before the arbitration was that I have clearly made an objection. However, the learned arbitrator...
Mr. Counsel,
yes.
one thing. Who submitted the statement of claims?
Statement of claims was submitted by the respondent number 1.
Then you filed a counter to that.
I have clearly mentioned before the learned arbitrator that I have a strong objection, but the...
Yes. Mr. Counsel, your strong objection is, whether it's a strong objection or a weak objection, that's not the issue.
My lord.
The issue is whether your appeal comes within the provisions of section 34. Which one? It comes under which one?
My lord, what I'm trying to say is that in spite this Roman 4 states that not falling within the terms of submission to arbitration. I have made a submission, my lord. However,
What was the terms of submission? What was the terms of reference?
my lord, this will be at page number 31. Page number 31. This has been...
Okay, why did the other side go for arbitration? What was the issue? What were they aggrieved with?
My lord, they were aggrieved with non-releasing of compensation over as assessed for the land values.
For the
Land values.
So did the arbitrator give them land value?
My lord, yes. At page number 40. My lord, the arbitrator in his order, at page number 47 and 48, land value, this has not been given, my lord.
Not been given.
Not given.
Then what is your grievance?
However, my lord, the respondent number 1 herein had approached the learned arbitrator for releasing compensation already assessed land values.
Mr. Counsel, when he is not being given compensation for land, what can be your grievance?
My lord, the assessment over the crops and the assets of the respondent herein had been calculated by the learned arbitrator, and my grievance is that in the verification that was done over the lands of the respondent number 1 herein, I was not represented, my lord.
Where have you taken that ground? You are not represented in your pleading. Don't make up stories as you start the submission. Don't make up stories. It will be to your detriment. How did you go to the arbitrator? Was there a writ petition filed or what?
No, my lord. There was no writ petition filed.
He went directly to the arbitrator.
Yes.
And you participated. So nothing
Yes.
wrong.
Yes.
You participated in the arbitration proceeding.
Yes.
Now, where is the statement of claims made by him? Let us see. What is his claim?
My lord, this will be from page number 31 and 32. Page number 31.
Where is the initial letter? Where is his prayer that the matter should be referred to arbitration?
My lord, other than this letter, there is no. I've not
So
attached
out
any
here,
other letters.
the property values assessed on sale were excluded. Come to page 31, the
Yes.
last para.
My lord,
Consequently, a complaint was submitted to the Deputy Commissioner.
my lord.
So where is that complaint?
My lord, this complaint has not been annexed along with the
Then?
present petition.
Then why are you saying that this is the only letter? There is some other letter. Where is the earlier assessment? Where is the assessment made? Earlier assessment. You're not at all read.
This,
Where is the earlier assessment made by the NHIDCL or by the Kala for payment of compensation? Where is it?
my lord, that has not been annexed along with the
And what kind of appeal is this? Documents are not here. There's no case then. You've got no case. What is your grievance? I fail to understand. How does any of your issues come within section 34? It's not made out.
And my lord, I have raised a ground that this surveyor, Mr. Ardia, which is mentioned at page number 31, even this person has not been called upon, my lord.
Huh?
Even this surveyor, Mr. Ardia, was never called upon to be examined as to the veracity of his assessment, my lord. He was never called, my lord.
He was never called, but did you accept his verification?
No, my lord. We did not accept his verification.
Let us see what the arbitrator says.
And
Let us see what the
yes.
arbitrator says.
The arbitrator, he will mention at page number 42, paragraph 5, last line, that representatives of NHIDCL also do not object the complaint.
Then?
This is also one of the grounds why we are being aggrieved, my lord.
You see, if we do not know what has taken place in the court, we do not know what has taken place in the arbitrator's office.
My lord.
Now, if you want to challenge that statement
My lord.
made by the arbitrator, then you've got to file a review to that arbitrator saying that this is not what we have said. Can a review be filed against an award? What?
My lord, being
Where does it say, page 42?
page 42, paragraph 5, last line. Last line. Representatives of NHIDCL also do not object the complaint.
Also not object the complaint. Also not object the complaint. Where is the complaint?
My lord, complaint so far as the instant application, this is at page number 31 as referred before.
So the reassessment was made. So what is wrong?
My lord, reassessment was made, and this person who had made the assessment, he was never called before the...
Where have you said that?
In my grounds, my lord. It starts from page number 18, para Roman 5, grounds.
Since the said surveyor could not manage top assess all the properties. What is all this English? I'm not reading head or tail. What is this? Since the surveyor could not manage top assess all.
if I may take your lordship to page number 19.
This is your appeal, this is your
My
file.
lord.
Top assess, what do you mean top assess?
This, my lord, this has to be clerical, typographical mistake.
What should it be?
2. P should not be there, my lord. Page number 19, 8th line from the bottom.
So basically your case is that no evidence was led.
My lord,
Say that.
my lord.
That is the issue. Yes, Mr. Counsel.
Yes, my lord. As per the last court order of this honorable court, we can see that the arbitral award cannot be enlarged under section 37 of their, which is their main section for appeal. And at the same time, lordship, this honorable court had stated that the appellant is that the appellant stated that, lordship, they did not follow section 3G, subsection 7 of the National Highway Act in their appeal. That is one of their grievances.
You see, the thing that they are saying
Yes.
is that the compensation that has been made payable now is based on the assessment made by the
Yes.
surveyor. And no evidence was led. Is it true?
Lordship, with regard to that, the surveyor report alone is also part of the court record actually.
Was he examined in court, the surveyor? I mean, by the arbitrator, was he examined by the arbitrator? And was they allowed to cross-examine the surveyor?
Lordship, with regard to that, I did not have a clear information, but in the arbitral award itself, the NHIDCL representative has clearly stated that they doesn't have any objection with regard to the assessment.
Where does it say that? Page?
Page number 47 of their appeal petition, Lordship. That is the arbitral award.
47, yes. Where?
Yes, para 9.
Para 9, yes.
Yes. May I read, Lordship?
Yes.
The matter and report of Kala Khozol is examined carefully. The only benefit that entitled by the applicant is the asset value, such as asset value of crop damage and property damage as per reassessment done on 14/10/2021. As Kala fulfilled the provision contained in section 28 and 29 of the So Act, representative and engineer concerned in respect of NHIDCL has no objection while this arbitration case was heard. And beside, Lordship, if I may take you again into page number 60 of their appeal petition, 60.
Yes.
That is their appeal petition before the additional district and session Judge Champai. In that appeal, Union of India as well as NHIDCL by making a joint appeal. In that appeal, para 13 in that page of
Yes.
yes, Merry Lordship, that the Deputy Commissioner Kala Khozol has been impleaded as a party respondent in the instant appeal petition for the interest of proper adjudication of the matter, whereas the appellant have no grievance against the said respondent. So, Lordship, NHIDCL had also clearly stated that they did not have any grievance against Kala. That is with regard to their assessment. So, Lordship, if they did not have any grievance, actually they have no reasonable grounds at all.
So earlier, your land has been acquired
Yes, Lordship.
for road construction,
Yes.
and you are not happy for not getting land value, or what?
Yes, actually, Lordship, there is assessment was done for 2 times. On, if I may take you again to Lordship, page number 42.
Yes.
Yes, in that para number 5.
Yes.
Yes, there we can see that survey was conducted on dated 16/3/2021 and 23.
Where? Okay.
Yes,
Yes, on top.
yes.
AR is what? AR is?
Uh, applicant representative.
You are the applicant representative.
Yes. During that time, Kalian Tir was actually represented by his son-in-law. Yes, Lordship, in that para number 5, there we can see that assessment was done on dated 16/3/2021 and 23/3/2021. However, it is very unfortunate that
16/3/2021 and 14/10/2021.
no, Lordship, 23/3/2021. That 14/10,
23/3/2021.
yes, the first assessment was done on 16/3/2021, and during that time, the surveyor did not complete on that day, so he continued again on 23/3/2021.
Okay.
Yes, and however, it is very unfortunate that the assessment on 16/3/2021, I have not placed signature on that assessment sheet, so
You did not place, but they placed.
tw- 23/3/2021, I was given only on that basis. So I was aggrieved on that. So I made a complaint again to the competent authority, and as per their direction, reassessment was conducted on 14/10/2021, and based on that reassessment is now the main grievance by the
What is
present
the difference between the assessment made earlier and 14/10/2021? What is the difference?
Lordship, in 14/10/2021, assessment was much.
Just a minute, I don't know, I should have read. What is the reassessment? Where is the reassessment? Page?
Reassessment. Page number 43, Lordship. At 7.1.
You've got everything in the garden, huh? $52 lakhs.
My lord, 52 lakhs.
I do bonds or something, baby. Everything under the sun you've got growing in your garden. How is it possible? Huh? How is it possible? Everything under the sun you've got growing. Yes, so
So, Lordship, the difference between the two assessment, that is 23/2021 and 40/10/2021, is that in the first assessment, I was
in the
given,
first assessment, how much was it?
along with Solicium, only 12 lakhs, about 12 lakhs, Lordship.
And now suddenly it comes to 52 lakhs.
Because, Lordship, in that second assessment,
And in that first assessment includes Solicium.
yes,
But let us see the first assessment. Page?
42.
page number 42. Page number 42, paragraph, in the second paragraph, which is actually given as paragraph 5.
Let us see this. Where is this assessment? Let us see. Where is this assessment?
Lordship, actually that
My
assessment,
lord, if I may, I have not placed the assessment sheet before this honorable court because this was not in my possession at the time of filing of the case.
Is it now in your possession?
My lord,
Though, huh?
I will have to take instructions, my lord. If your lordship permits,
Yes, who's for Kala?
and my lord, in the meantime, let my learned friend also submit his power.
Because this is too much. Right.
Lordship, may I? Actually, the amount was increased because in the second assessment, my property assets, damage value were included.
Damage value was included.
Yes, property damage value were included in the second assessment. That is the reason.
6.
And what was but why was damage value included? Was it a part of the reference?
Because, Lordship, in that second assessment, all my farmhouse as well as water tanki like that were.
This page 43 does not show that. How much was the assessment? 52 lakhs does not show about damage to house.
My lord, the total assessed amount is rupees 68 lakhs.
Page.
Page number, addition of paragraph 7.1. Page 43, 43 and 44. 43, 44 and 45. The total amount from 7.1, 7.2 and will come up to rupees 68 lakhs 26,353. This 7.1 in the table, this is only for crops and trees. And apart from this, my lord, and there are assessed estimates from para number 7.2. So if we add that all up, it will come to 68 lakhs, 26,353.
And the person who made the assessment was not examined by you?
No, my lord.
Right. Mr. Tilal Zakima appears for the appellant, while Mr.
Ke Kham Thian Manga. Ke Kham Thian Manga.
appears for the respondent.
Respondent number 1.
Respondent number 1. Who's for respondent number 2? Who is for respondent number 2? Who is respondent number 2?
Respondent
Kala?
number 2 is Kala.
Kala Khozol.
No one appears for respondent number 2, bracket Kala. Even though office note indicates that AD cards for service of notice upon the respondents has been received. It is surprising that Kala, who is the Deputy Commissioner Khozol, has not entered appearance till date. You tell them to appear, madam. Yes, sir. Otherwise, we'll call them here. The appellant's case is that the reassessment of the damages payable to the respondent number 1 for acquisition of this land had been done on the basis of the surveyor's report dated 14/10/2021 without any opportunity being given to the appellant to cross-examine the said surveyor. He submits that because of the reassessment made by the surveyor on 14/10/2021, the compensation amount payable to the petitioner, besides the amount already paid, vis-a-vis the earlier assessment made, amounts to rupees. How much is the difference?
Total amount, my lord, is
Difference.
If
Yes,
if I may, my lord.
take your time.
$55 lakhs 53,873.
Okay.
555,53873.
First up, he submits that the direction of the Kala, the direction of the Kala basically,
My lord.
to pay the said amount to the respondent number 1 is perverse as the same is based on no evidence. Full stop. On the other hand, the counsel for the respondent number 1 has pointed out that the NHIDCL had no objection to the payment of compensation to the respondent number 1 in terms of the reassessment done on 14/10/2021, which has been reflected in para 9 of the Arbitrator's Award dated 15/3/2024, bracket, page 47. He further submits that the appellant in para 13 of their appeal filed under section 34 of the Arbitration and Conciliation Act 1996 had stated that the appellants had no grievance against the respondent number 2, bracket Khalid. Thus, when the appellants have stated that they have no grievance against the respondent number 2 in their appeal filed under section 34, they could not have any objection against the reassessment made on 14/10/2021. Which is in relation to the compensation payable to the respondent number 1. In terms of the reassessment. So, we can dispose of this case either way it can go. Now, only thing is you have got to file a wakalatnama. When did you file?
During the course of the day, Lordship.
Okay, Mr. Swenson submits that he will file his wakalatnama during the course of the day. Leaves the matter when? Tomorrow?
My Lord,
Lordship, if possible, day after tomorrow.
After
Thursday,
tomorrow, I am not. It's
holiday.
It's
Thursday
a
is
holiday. You'll be the
Tomorrow,
only
no
one
problem, Lordship, from my side.
tomorrow.
my Lord, what about the respondent number 2?
He is not here. We'll do it without him.
My Lord. Obliged.
Item number 3.
Hello. Okay, we'll do it Friday.
Friday. But my lord, my lord, in this case,
Not you. I'm talking to T. Lal Zakima.
Lal Sikima,
Yes, yes.
my lord, item number 3.
Yes.
My lord, in this case, I've been instructed, my lord, to withdraw with a liberty, my lord, if it's possible. My lord, Mr. Soirema, he's the leading counsel in this case, so he has asked me this morning, my lord. We'll file it, possible, we'll file a new case, my lord.
Okay, right, Mr. Joseph L. Leonard, counsel for the appellant, please that he may be allowed to withdraw the appeal with liberty to file afresh.
Deeply obliged, lord.
Full stop. The same is allowed. Full stop. Appeal is accordingly dismissed with liberty as prayed for. As per law. Huh?
Deeply obliged.
Item number 4.
Yes, Mr. Kartik Jain.
My lord, in item number 4, the notice has been issued and the copy has been served through court.
So what is your case here? You are for item 4, Mr. Counsel? You are for item 4?
No, Lordship. Item.
Yes, your address is insufficient.
Sorry, my lords, address hasn't.
Huh?
My lord, we'll look into it again. We have served the copy through court only, so we'll look into it again with the registry.
Who appears for the other side? Anyone? No one. Right. Mr. Kartik Jain appears for the appellant. No one appears for the respondents. As per office note dated 10/2/2026. 10/2, where is the latest? No, wait. You please call this registry, this person. What do you mean has been returned? Has been returned with, has been received by the respondent or not? It's been returned what? What does the report say? Has been given, not given, what? Call him. Call the registry, call that concerned person who wrote that note. Next.
Item number 5.
Yes, you are appearing for whom?
May it please your lordship, I am appearing for respondents number 1 and 2.
1 and 2.
Yes. Lordship, I have only been recently engaged. I have not received the full sets of the pleadings. So perhaps, if your lordship allows,
Why
this
is
matter.
this Kala not appearing? I'm going to call them by personally. None of the cases. What is this? I'm going to call this DC. From now on, all the cases, all the DCs will have to come. What is this? Right. They are performer respondent. Someone has to take notice. They are government officials, madam.
Yes, only in few cases they engage the GAs, only in few cases, not all. Let me inform them my lord once.
Right.
My lord, I have to request something. My lord, there are two major issues in this matter. One is with respect of revised valuation. Second was that 6 property later were included by learned arbitrator.
What was included?
6 buildings which were excluded in 3G award by learned arbitrator, those were included in the award. So my lord, with respect to that, we have a recent update of a satellite report which pertain to the date prior to freezing order or near to the freezing order, which clearly determines that the date on freezing order, those 6 property were not there on the land.
They were subsequently constructed.
Yes, so with respect to that, I would like to request my lord to allow us to file an additional affidavit with respect to the submission of that report before the Honorable Court.
So the arbitrator's award contains those 6 buildings, the compensation for the 6 buildings which was not there in the 3G award.
Yes, my lords.
Right. Mr. Kartik Jain, Learned Counsel for the Appearance, submits that in the award passed by the arbitrator, there is compensation awarded for 6 buildings which were not included in the 3G award
Yes,
made by the respondent number 3,
Kala.
Kala. So Kala then cannot be a performer then. Kala cannot be a performer respondent then.
Understand.
Oh no, it is a, okay, next. He submits that as per What do you see? As per what data? What she?
Satellite data.
He submits that as per satellite images.
Satellite images.
Satellite images / data. There were no buildings on the land acquired, on the land of the respondents acquired by the appellant at the time of freezing of the land,
Yes, freezing order.
freezing order of the land made under section
3A. 3A.
3A of what?
National Highway Act, my lords.
Huh?
National Highway Act.
National Highway Act 1956.
Yes, my lords.
Let's see, just check. Yes, madam, you are the, madam, one thing. Huh? No, don't shout. Madam, don't shout. Don't shout in court. Is the section correct?
Yes, my lords may refer to page 38, which is a freezing order. My lord, actually it is issued by Land Revenue and Settlement Department, but this pertains notification under
Yes.
section 3 of the said act.
You see, next time when you write that the AD cards have been returned, please say that it is signed by the respondent concerned and that notice is served or something like that. It is saying return what? Return, is it returned empty-handed, returned without signature, with signature? You've got to mention. You make that statement, you make the report. What have you said?
My lord may say that the freezing order was issued by the Land Revenue and Settlement
Freezing
Department.
order issued by the Land Revenue and Settlement Department on 1/6/2020.
Yes, my lords.
That's all? And here the last sentence. Fishing water? Let's read from the beginning.
He submits that as per satellite image of the data, there was no building on the land of
Respondents. Two.
respondent number 2 acquired by appellant.
No. There was no buildings on the lands of the respondents acquired by the appellant. Full stop. Acquired by the appellants in terms of section 3 bracket small a.
Yes. Capital A.
Capital A. 3A capital. Of the National Highways Act 1956. He accordingly prays that he may be allowed to file an additional affidavit.
Yes.
The prayer is allowed. Then what is the other ground of challenge you said?
There were two main issues: revised valuation of land, and second.
And what revised valuation of land? What was your grievance?
My grievance was that the rate has been revised without adducing any evidence to justify the revised.
So next, the learned counsel submits that the rates of compensation payable to the respondents has been revised without any evidence to that effect being adduced by the learned arbitrator.
Yes, ma'am.
Any other thing?
That were the two main issues in this matter.
List the matter, give a date after 4 weeks.
Item number 6.
What is the date? Give the date. 4 weeks from now.
21st of April.
In item 6, Lordship, I'm representing respondent number 1.
Have you filed a wakalat?
Yes, Lordship.
I have Mr. So-and-so appears for respondent number 1 and 2.
Respondent number one and two.
Appears for respondent number 1. Again, scholarship. And why do you make them perform? I don't know.
Well, we'll definitely rectify the same in the next appeal, whatever we submit.
What is your grievance here?
My lord, the grievances is with respect to the 5 structures again. The challenge was that this structure does not.
Against revised compensation amount.
Yes. With respect to the freezing order, these were constructed prior to freezing order, but later, before the learned
Yes.
arbitrator, these have been included.
What to do? Are you ready?
No, Lordship.
Why?
As I have submitted earlier, Lordship, I have just been recently engaged.
Or recently? You have not filed a wakalat.
We have filed, but we had not received the complete set of the
Oh,
pleadings.
yes. Mr. Give him a copy.
No, from our clients, Lordship.
Or from your client.
clients
That is
had
your
received-
problem.
Our clients had received, but we had not received it directly from them.
When did you file
So
a wakalat
perhaps-
nama here?
Not so long ago, Lordship.
How, when?
Perhaps 2 weeks earlier.
2 weeks is more than enough time, Mr. Counsel. I read this when?
So perhaps, Lordship, if this matter may be listed with the rest of the cases.
Day after tomorrow? I mean, on Friday? It's a small issue.
No, Lordship.
It's a small issue.
Along with item number 5.
Okay. Let this matter along with so-and-so.
It's on
On so-and-so.
21st of April. Item number 7.
In item 7, same prayer, Lordship.
Why? Why should it be together? They are all different cases. No. 6 and 7, this is them Friday. This is the Friday. We'll dispose it over Friday.
6th and 7th for Friday.
But Lordship, Kala is also yet to be
It's
represented
okay,
in these
they're not
cases.
there. We'll see if they're required or not.
Obliged.
It's only one thing, only one ground. Whether the enhancement of the compensation has been done after taking evidence. So you'll have to only settle one thing, whether any evidence was taken. If no evidence was taken, we'll send it back to the arbitrator to take a decision after taking evidence, simple as that. Because if a finding has been made without any evidence, without giving them a chance to cross-examine the witness, then it's a perverse order. That's all. It's a small issue, very small issue. Okay. Now the other issue, the other one we gave time because now there has been a change in the facts. There were no houses, suddenly 6 houses have come out from thin air. So that's a different thing. Whether that is correct or not, we will have to see. Okay.
Right.
So you just tomorrow, only that issue.
My lord.
The issue is what is the compensation given under 3G. Then arbitrator has given a separate award, enhance the compensation amount. Correct?
Yes, my lords.
On the basis of some report which apparently does not seem to have been, has been, no evidence was taken on that, on the same. Just that, just see that. Friday.
My lord. We are obliged.
Obliged, my lords.
Item number 8.
Please, Your Worship. As per the permission of this Honorable Court, we had issued notice to the respondent 5 and 6 through newspaper publication. And the newspapers have also been filed by way of an affidavit. In pursuance of that, respondent 6 has engaged my learned friend.
I'm appearing for 6, my lord.
And respondent 5 is still absent today, although notice was issued in the newspaper, Wanglaini and Aizol Post. So
Where is your affidavit to that aspect?
it's then,
If you have filed it?
yes, sir.
Okay. This matter pertains to?
Your land dispute, overlapping of LSCs.
Oh.
In pursuance of that,
You can start.
Your Lordship, I have not yet been supplied a paper book.
in pursuance of that, respondent 6 has appeared, 5 may be deemed to be complete, Your Worship.
Okay, right. An affidavit has been filed by the appellant regarding newspaper publication of the notice to the respondents number 5 and 6. Pursuant to the order dated 19/1/2026, showing that notices have been issued in two newspapers.
2, yes.
Two,
2. Wanglaini and Aizol Post.
as stated in the order. Mr. Joseph L. Densey appears for the respondent number
6.
6 and submits that he has not been given a copy of the paper book. The same to be furnished by the registry at the cost of the appellant. As newspaper publication has been done, notice is deemed to be served upon the respondent number 5. List the matter after 3 weeks.
3 weeks.
23rd of April. For hearing item number 1.
Yes.
May it please your Lordship. My Lord, this is a jail appeal challenging the judgment and order of conviction dated 17/05/2024. This is at starts from page number 51 to 78.
My Lord, if I may, Miss, this two cases, this hearing cases, it's taken up by Miss Mary and she's on leave.
Doesn't matter.
And Miss Vani is taking up this matter,
We'll
item number 1.
We will
She's
take up,
on legs, my
we
lord.
will take up one just now.
She's on legs, my Lord.
You see, you are still there, you are the PP, we'll give you a copy. Give her a copy of the second, yes. Give her a copy of the paper book, second copy. You have got? Madam, you don't have. Give. It's a very simple matter. There are two injured eyewitnesses are there. They have both been stabbed. There's nothing to, there's no escape in this case.
My Lord, the main grounds will be that the ingredients of this section 307, section 326, my Lord, that has not been proved. In fact, my Lord, in order for conviction under these two sections, the ingredients which are intention, my Lord, intention, and that knowledge, that has not been proved by the prosecution, my Lord.
Okay, but the act was there. The
act
act
was there, my Lord. However, that intention was not proved.
Intention not proved.
Yes.
Please see. So your only case is intention not proved.
Yes,
So if
and-
intention is not proved, then what happens?
And
No, you tell me.
my lord,
Supposing we agree with you that the intention has not been proved, then what happens?
my lord,
Then they have to be acquitted.
my lord, then the conviction under this particular sections, my lord, this will have to be set aside and quashed. And if this and
So,
and-
how can it be?
and another point,
So how do you prove intention? Why do you say intention not proved?
my lord, that has not been let into evidence by the prosecution.
When the fact is so clear, what do you mean intention?
And on the facts of the case, my lord, in the FIR,
Let us see the evidence. Let us see the evidence.
yes, my lord, before coming to the evidence, my lord, if I may make one small submission, in the FIR, it has been clearly stated that the appellant accused herein was in a state of a drunken stupor.
So,
And so, my lord, that that's
you cannot
and-
you cannot take that benefit. You cannot take that
so-
benefit.
Yes. However, my lord, being him in a drunken state, my lord, then he had no prior knowledge, or that there is no
Yes.
proof that he had
Give me IPC.
intention, my lord.
And you give one IPC to the BPO. Look, for that, drunken, okay, so according to you, drunken stupor.
Yes. Drunken stupor. This stupor
Drunken
is the
stupor,
word.
so
my lord.
he had no prior knowledge.
Yes.
No prior knowledge of what?
And that, my lord, and that
No prior knowledge of what?
that he had no prior intention to cause that grievous hurt, my lord.
Okay.
And if we take on the face value of this the word stupor, my lord, according to the Merriam-Webster dictionary, it means that complete suspension of the sense or sensibility.
Okay. Now, to hide behind that,
My lord.
to hide behind the fact that you were drunk, you have to come to section 86,
My lord.
IPC.
Yes.
Read that.
My lord, in that I have to be administered by that substance has to be
Yes.
administered on me.
Yes.
Which in this case was not the case, my lord.
No.
How?
That's
Yes.
what.
Yes.
So out there, though, you had drunk it yourself. No one forced you to drink the liquor.
Yes, my lord.
Then, if that is the case,
Yes.
where is the question of you not having knowledge?
My lord, in this instant case, I am not hiding behind this protection of section 86. My lord. However, the ingredients of the offense, my lord, this has to be proved beyond reasonable doubt by the prosecution. That is my case.
So that is why let us read the evidence.
My lord.
Let us read the evidence.
My
Let us go first straight away to PW1.
PW1, page number 5. I apologize. This is the 313 statement,
Page 33.
my lord. If I may.
Yes?
I am the complainant as well as the victim in connection with the instant case. The accused, Zaider Zava, is my uncle. I live in two-story Assam-type building at Salem Veng, Aizawl, and the accused person live in the ground floor, whereas we live on the first floor of the said building. The accused person has been addicted to drug and alcohol and used to create trouble, physical violence, in our family for several times. The accused person usually gets angry with no reason when he gets drunk and intoxicated. On 20/08/2023, the accused person got very angry as he was drunk during that time. The accused person then shouted from his living floor, stating, "Ipa bula kathon bo donse, kathat donse." PW5 then approached the accused person and asked him, "Ithom dim de ro in chung bung ro it is henasat lutuk don." PW number 5, this is the father of the accused. The accused person suddenly went to our residence floor with a knife in his hand and stabbed me on my abdomen while I was lying on the bench. During that time, I tried my best effort to escape myself. I ordered to save my life from the action of the accused. My lord, I'm reading as it is. The accused person forcefully held my head and pointed his knife towards my neck, and I held the sharp side of the knife with my right hand in order to stop his action. And as a result, I got injured on my right hand. However, a simple slice injury was caused on my neck due to the action of the accused person. When PW5 heard our commotion, he ran up to our residence floor and grabbed the accused person away from me. I then ran inside my bedroom and locked the door. Even I got a severe injury on my abdomen and right hand. After around 5 minutes, our neighbors who heard our commotions inquired about our noise, and one of my friends, PW4, knocked the bedroom stating, "Lo hong ro, alo om to lo, lo chuak ro." When I stepped out from the bedroom, many neighbors were at our sitting room, and I saw PW5 injury stabbed by the accused person. Our neighbors took me and PW5 to the hospital for medication. Exhibits are given on cross-examination by the defense counsel. Number 1, it is not a fact that I never saw the accused drinking alcohol and doing drugs. It is not a fact that the accused never create trouble in our family. Though I have stated that the accused was drunk on 20/08/2023, I did not see him drink alcohol. I denied the suggestion that I do not know whether or not I was the one the accused was addressed to when he said, "Ipa bula kathon bodon che kathat don che." The accused was staying in his house, which was on the ground floor of our building, when he said, "Ipa bula kathon bodon che kathat don che," and I was in our house, which is the first floor of our building. It is not a fact that the accused did not enter into our house with a knife in his hand. It is also not a fact that the accused did not stab me on my abdomen while I was lying on the bench on 20/08/2023. When I said that the accused stabbed me on my abdomen while I was lying on the bench, I tried my best effort to escape myself. I ordered to save my life from the action of the accused. The accused person forcefully held my head and pointed his knife towards my neck, and I held the sharp side of the knife with my right hand in order to stop his action, and as a result, I got injured on my right hand. However, a simple slice injury was caused on my neck due to the action of the accused person, as mentioned in my examination in chief. I was with my friend Zodin Pui and my 4-year-old daughter in our house. It is not a fact that I did not see PW5 coming inside our house. It is a fact that when our neighbors came into our house, I was inside the bedroom, and before I went out of our bedroom, I did not see anyone coming into our house. Though I have stated that when I stepped out from the bedroom, many neighbors were at our sitting room, and I saw PW5 injury stabbed by the accused person. I did see the accused stabbing PW5. The FIR was drafted by the police personnel under my instruction. I denied the suggestion that the accused had no intention to hurt or kill me on 20/08/2023. I denied the suggestion that the FIR was not submitted as per my wishes. I went to the civil hospital Aizawl on 20/08/2023 at around 7 to 7:30 p.m. It is not a fact that the accused is falsely implicated in this case. It is not a fact that I am deposing falsely before the court today.
Yes. Come to PW3.
PW number 3. Page number 38.
I think it's the same thing. Same as 2.
Yes, same as 2.
Now come to 4.
These are Caesar witnesses.
Come to 4. 4 is the friend.
Yes, the eyewitness. I am currently living at Salemveng with my mother. I have known the family of the accused since childhood, as we reside in the same locality and our house is not far from each other. I regularly visited them at their house. On 28/2023 Sunday after dinner, I visited the residence of my friend Lal Shuai Tlong, complainant. We were just chatting, and the accused shouted at Shuai by saying, Lal Shuai Tlong Kathat Don Se, while at the same time he was throwing and kicking at household items. Pulura PW5 went downstairs to stop the accused from creating trouble, and soon after the accused came up to where we were. He was holding a knife and he shouted at Shuai and stabbed her around the abdomen area, and they struggled. The accused also tried to slash the throat of Shuai, complainant, but she managed to escape and went inside the bedroom and locked the door. I was frozen in fear and I was afraid that he might stab me too, so I just stood at the corner. Pulura PW5 rushed inside the room where we were, and the accused slashed and stabbed him on his abdomen area, and at the same time people started to gather and they apprehended the accused. I knocked on the bedroom door and told Shuai to open the door as it was safe, and I accompanied Shuai, complainant, and Pulura PW5 to Civil Hospital Aizol. The accused, since I have known him, has created problems regularly when he is drunk, and he used to lay his hands on Pulura PW5 and Shuai, complainant, a number of times. Pulura PW5, Shuai, complainant, and Malsom Dongleni, daughter of the accused, used to report the accused to police a number of times, even before this case, as he used to regularly create trouble at home and used to lay hands on his family members. The police have arrested him around 2 or 3 times previously, and I know that he has been jailed 2 times for creating trouble and laying hands on his family members. On cross-examination, it is not a fact that I did not see the accused holding a knife. It is a fact that I did not see the accused stabbing Shuai. It is not a fact that I did not see the accused try to slash the throat of Shuai. I did not see the accused stab Pulura, but I saw him waving his hand, carrying a knife, and slightly slash the abdomen of Pulura. It is not a fact that whenever I have stated in my examination in chief are based on the information I have received from others. It is not a fact that I have no direct knowledge about the instant case. It is not a fact that I am deposing falsely before the court today. PW5, this is also one of the victims, madam.
Please read.
Madam.
PW5 is the most important
My Lord.
also.
I am one of the victims in connection with the instant case. The accused Aidarzawa is my elder
Is
son.
my elder son.
Elder son.
Son slashing the
My Lord. My Lord. And I live in 2-story Assam type building at Salem Veng, Aizol, and the accused person live in the ground floor, whereas we live in the first floor of the said building. The accused person has been addicted to drug and alcohol and used to create trouble, physical violence in our family for several times. The accused person usually gets angry with no reason when he gets drunk and intoxicated. On 20/08/2023, the accused person got very angry as he was drunk during that time. The accused person then shouted towards PW number 1 stating, Ipabula kathon bodonse, kathadonse. I then interfered and approached the accused person and asked him, Itom dimdoro in chung bungro iti chenasat lutukdon. The accused person suddenly went to the first floor of the building with a knife in his hand and stabbed PW number 1 on her abdomen while she was lying on the bench. During that time, I suddenly proceeded towards the first floor of the building in order to stop the action of the accused person. I then grabbed the accused person away from PW number 1 after he stabbed her on her abdomen, and while the accused person intended to stab PW number 1 on her neck by using a knife. PW number 1 then suddenly ran into the bedroom with severe injury. The accused person then stabbed me on the left side of my abdomen by using the same knife. I pushed the accused person away from me, though he stabbed me on my abdomen. A lot of blood came out from my injury and I almost fainted. And during that time, our neighbors arrived at our residence. They heard our commotion. As they heard our commotion, our neighbors took me and PW1 to the hospital for medication. Hence, FIR was lodged by PW number 1 to colleague on PS about this incident. On cross-examination, it is a fact that I did not see the accused stabbing PW number 1 on her abdomen while she was lying on the bench. I did not make any complaint against the accused in connection with this case. It is not the fact that the accused did not stab me on my abdomen. It is not the fact that the contents of my examination in chief are false and baseless. It is not the fact that I am deposing falsely before the court today.
So the medical evidence also proves, in fact, the cross-examination
My lord,
proves that. And then you come to 313,
my lord,
page 5.
page 5. Question number 1, if I may.
Yes.
PW number 1, Lal Shuai Tluangi deposed that you are her uncle and that you live in the same building and you live...
Come to question number 2.
Question number 2.
Yes.
PW number 2 further deposed that on 20/08/2023 you got very angry as you were drunk and you shouted from your house saying Ipabula kathon bodon che kathadon che. Then your father PW5 approached you and said itom dim de ro in chung bung ro ite chen sal tukdon. Then you suddenly came up to their residence holding a knife and you stabbed her on her abdomen while she was lying on the bench. That she tried to escape in order to save her life from your action, you forcefully hold her head and pointed the knife towards her neck, and she held the sharp end of the knife with her right hand in order to stop you. That she got injured on her right hand and another simple slice injury on my neck. Is it true? What do you have to say in your evidence? Answer: it is correct that I slightly stabbed her on her abdomen. She was drinking alcohol the day before the incident and I was scolding her and we were arguing. However, I do not remember using abusive words her as she alleged.
So, what more do you want? You have proved. You have also admitted in your 313. And then come to the next question.
My lord. Question number 3.
Yes.
PW number 1 further deposed that then your father heard the commotion. He came running to the house and grabbed you away from her, and she ran inside her bedroom and locked the door. And after around 5 minutes, their neighbor inquired the matter. Upon hearing their commotion, and her friend PW number 4 knocked her bedroom saying it was safe and asked her to come out. When she stepped out from her bedroom, many neighbors were at their sitting room and she saw your father's stab injury caused by you. And their neighbors took her and your father to the hospital. Is it true? Do you have anything to say in your evidence? It is correct. However, I accidentally, my lord, I accidentally stabbed him during a struggle and I had no intention to stab him or cause him any injury to him.
So, yes. Now you come to, I think all this is incorrect, whatnot. Then,
in my lord, if I may take your lordship to the answer to question number 8.
Yes.
Page number 8, in the last line.
Correct.
I was drunk and I do not remember every detail of how it's...
Correct.
My lord.
Correct. Not only that, he has said it again in the same thing.
My lord.
In para 16, question 16.
Yes.
Page
Question
10.
16. Yes. I was drunk at the time of the incident and the incident is involuntary and I had no intention of causing death to my father or my niece.
So you want to take the advantage of 86 only. Only 86 can help you. But 86 requires that you should administer.
Yes.
You should have been administered the drink, possibly.
Yes, my lord.
By others.
And my lord, there are also some inconsistencies because the PW number 4 had stated, PW number 4 was the eyewitness. She had stated that the instant accused, appellant, had been sent to jail 2 times.
So,
and in this, in his 313 answer, in his answer to question number 9, at page number 8, he had denied the same.
how does it matter?
And
Those are the matter in issue.
Yes.
Is not about whether he went to jail or not.
My lord.
The subject matter in issue is whether he stabbed his niece
Yes.
in the abdomen and his father.
My lord.
And they both survived to tell the tale. Now,
My lord.
why should the father make a fabricated case against you? Any reason, any enmity between you two?
None, my lord.
None. Then why should the niece make a fabricated case against you?
My lord, if your lordship will kindly come to page number 91 and 92. This is the letter
91.
written by PW number 5,
Yes,
the father.
yes.
91 is the vernacular, and 92 is the English the translated version. My lord, which
Anyone?
anyone? I think it will be more beneficial if I read the vernacular, my lord. Page number 91. Kapu kehi h vanlal lura salem veng achunga katarlan thu boy nei tu le shremlai mek zai dar zawa pa takhi kani a tin he thu boya victim hi kani e ka fapa zai dar zawan thil swal ke le afanu katunu chunga ati hi dan anga an shrem nge hi kapoma amai ro chu danin ashem reizong turte kan lo thiam lo ani dan in ngai dam ro se ti hi kadu ani lo chungin tuna ashem na hi nep saktura high court appeal hi chu
That is neither here nor there. Is it a compoundable offense? Not a compoundable offense.
No. And regarding my lord 313 questions 313 examinations, my lord, the questions put on the accused, the appellant, my lord, these are very casual, and my lord, this shows
very casual, not casual at all.
If your lordship will come to page question number 13, this is at page number 9.
There's no point. It's quite clear. It's a clear case. It's a clear case. It's an injured witness.
My lord.
And there also the niece and the father.
And yes,
Any citations?
I have, my lord.
Okay, good. But it should be relevant. Huh? Don't give citation just for the sake of giving.
My lord. My lord, 1972 3 SEC, 1972 volume 3 SEC, page 22. Dr. S.L. Goswami versus State of Madhya Pradesh. Para 6. It basically says that all the ingredients of an offense has to be proved by the prosecution.
It's been proved. You have also proved it.
My lord,
Not only the prosecution, you yourself have proved it also. Let us see the charge framed against you. At the time of framing of charge, page 3. Come to page 3.
Yes.
Claim to be tried.
Firstly, that you own so and so.
Okay, then we have read. Then you claim to be tried.
Yes,
Okay.
307.
Then, okay. Now, the thing is that, look, these survivors, your niece, your father, what more do you want? What is this judgment? That para 6 says what? Yes, this is their honors of proving that.
Yes.
You see, these are all the general law. Don't put general law. There's nothing here. Don't give us a citation just because you want to show that you want to show that you have done some work.
And my lord,
it has to have some relevance, your citation. You can give me 1,000 citations, I know. Even I can give you 1,000.
my lord.
But then it has to have some basis with regard to your submissions. This is nothing. It's general law.
My lord, regarding this 326 IPC, it clearly states voluntary. Now, voluntary has been defined at section 39.
So,
Section 39, and
so you mean to say that your action was not voluntary?
not voluntary.
What was it? Involuntary?
Yes, my lord, involuntary, as stated in my 313 statement, my
So
lord.
how does it matter if it's involuntary? What do you mean involuntary?
So-
That you were possessed by some demon and you had no control over your body or what?
My lord, if if I am to be convicted under this section, my lord, that the ingredients of that section, my lord, that has to be proved, my lord.
I think we have heard. Yes. So I think it's an open and shut case.
Yes, my lord. We have seen from the evidence of the prosecution that the present appellant used to regularly create trouble
No,
at
leaving
drunken
that
state.
aside.
Yes, and my lord, he has stabbed his own father and his niece at the same time.
Correct.
He has stabbed PW number 1, and while PW number 5, while trying to save PW number 1, PW number 5 was also stabbed. So, my lord, the case is very clear that he has stabbed, and we have the medical report also. And the 313, my lord, he has admitted that he used to be physically violent towards his family whenever he gets drunk. He has admitted that fact.
In question number?
My lord, in the question number 1,
Okay.
at page 5.
Any citations?
My lord, yes, I have few, but we have not. We have given one citation regarding an injured witness.
Give that.
Yes.
Injured witness.
2011, volume 4 SCC.
Citation?
2011, volume 4 SCC 324.
Para?
Para 27. May I read, my lord?
Correct.
Para 27 and para 36. And regarding intoxication, though we have not given the
Para
citation.
36.
Yes,
27 is enough.
all right. Regarding intoxication, 2023. Intoxication. 2023. Oh, it's SCC online, my lord. SC 1491.
SC 491.
1491.
1491.
1491. At para 17. It talks about section 86 of the IPC.
Give me that. Give it.
This one we
Okay,
have not
right.
given the citation.
My lord,
Heard.
if I may
Miss-
make one,
Yes.
the coordinate bench of this honorable court has passed a judgment on 29/10/2025 in almost similar case. In that case, my lord, the accused, the appellant, had assaulted his parents and attempted to kill them by using a wooden pestle, suk, mizo suk.
Correct.
And that in the evidence, it was adduced that he was drunk at the time, and that he was often drunk. And so the judgment rendered by this honorable court was that the conviction under that 307 was set aside in quash.
Look, this is
It's
a question
almost
of, you
yes.
see, the weapon is here is a knife, and you have stabbed someone in the abdomen.
My lord.
You don't do that for fun. Hitting someone with a wooden stick is different. The injuries are different. This cuts the skin. We do not know.
And why he was in that judgment, my lord, why he was why the conviction under 307 was set aside and quashed was that the prosecution had not proved the intention of the accused in that case.
Had not proved the intention.
Yes.
Out here, his intention is there. He's shouting, "I'm going to kill you." What more intention do you want? If I say I'm going to kill you, and then I come and stab you, is that not enough intention? What more do you want? What more do you want? When someone tells you, say a person comes shouting from here towards you, says, I'm going to kill you. And then he pokes you with a knife on your stomach.
My lord.
Oh, that is the intention. What more do you want? You wanted it written in the forehead that, yes, I am going to kill you. What do you want?
My lord, at the time of the incident, my
No
lord.
case, Mr. Counsel. Then I heard Mr. T. also came up. Learned amicus curiae for the appellant. Also heard Ms. Linda L. Fambo, PP. The appellant has put to challenge the impugned judgment and order dated 17/5/2024, passed by the Court of the Additional District and Session Judge -1, Aizawl, in SC number 113/2023, arising out of Kulikon PS case number 136/2023, by which the appellant has been convicted under section 307/326 IPC. The appellant has also been thus been sentenced to undergo rigorous imprisonment for 9 years with a fine of rupees 5,000, in default to suffer rigorous imprisonment for 5 months, another 5 months, under section 307 IPC. And to undergo rigorous imprisonment for a period of 7 years and to pay a fine of rupees 10,000, in default to suffer a rigorous imprisonment for another 3 months, under section 326 IPC. The sentences are to run concurrently. Next paragraph. The facts of the case, the fact that the appellant had stabbed his niece, bracket PW1, and his father, PW5, in the abdomen is not in dispute. It is also not in dispute that the hand of PW1 was cut while she defended herself from being stabbed in the neck, though stabbed in the neck. Though it appeared that, though a nick, wait. 34. Though it appeared that her neck also got nicked, N-I-C-K-E-D, nicked by the knife. Full stop. Next paragraph. The appellant's counsel submits that the impugned judgment and order should be set aside, inasmuch as, the prosecution had not proved that the appellant had the intention to stab PW1 and PW5 in the abdomen. Further, further, the appellant being a alcoholic or not? Further, being under the influence of liquor, comma, the intention to the intention to cause attempted murder did not arise, comma, as the appellant was in a drunken stupor. Full stop. He also submits that there was no prior intention on the part of the appellant to stab the victims. Full stop. Next para. On the other hand, the learned PP submits that the fact of the appellant having stabbed the victims is not a disputed question of fact. As the appellant in his statement, in his examination under section 313 CRPC has admitted to the same when answering question 9 and 10. She submits, the learned PP submits that though the appellant has tried to hide behind the plea that he was drunk at the time of the incident, comma, the same not the same. Section 86 IPC would not be applicable to the case of the appellant, as he has not taken a plea that the thing which intoxicated the appellant had been administered to him without his knowledge or against his will. She submits that as the victims are injured witnesses, the testimonies of PW 1 and 5 have to be accorded special status in law. Next, I have heard the counsels for the parties. The evidence of the niece of the appellant, that is PW1, is to the effect that, no, don't say that, cut all that, cut it. The brief facts of the case is that the niece of the appellant, PW1, had submitted an FIR dated 21/8 23. Which stated that at around 7:30 p.m. on 20/08/23, her father's elder brother, no, this is wrong. This translation is wrong. It says, my father's elder brother Zaid al-Zawa, who was highly intoxicated. Zaid al-Zawa is the victim.
Zaid
Zaid
my lord,
al-Zawa
is the accused.
The
accused. Okay. Is that her father's elder brother, bracket appellant, who was highly intoxicated, entered her house and grabbed a kitchen knife, which he stabbed on the stomach of the appellant. The appellant then pushed PW1 onto a chair and tried to slice her throat. PW1, in order to protect herself, kicked him and ran away from the house. And tried to protect herself, like she looked at, put her. Protect herself when he tried to stab her throat, when he tried to slice her throat. He then kicked him. Okay. Next part. Continue. During that time, her grandfather, bracket PW5, entered their house and pushed the appellant away. The appellant then ran into her room and locked herself inside as she was scared. Her friend Zodin Pui, bracket PW4, was present and witnessed the entire incident. After a while, her friend asked her to leave the room as other people had come into the house. She then realized that her grandfather, PW5, had been stabbed below his rib cage. Question 2. The FIR, the officer in charge of Kolikon police station, registered Kolikon PS case number 136/2023. 136/23, dated 21/8/23, under section 307/326. After investigation of the case by the investigating officer, bracket PW7, charge sheet was filed against the appellant, as a prima facie case under section 307 and 326 IPC was found established against the appellant. Next paragraph. The learned trial court thereafter framed charge under section 307 IPC and 326 IPC, to which the appellant pleaded not guilty and claimed to be tried. The learned trial court then examined 7 prosecution witnesses. No, 8 prosecution. No, 1, 2, 3, 4, 5, 6. Oh. 7 prosecution witnesses. And came to a finding that the appellant had intentionally stabbed the victim, they stabbed PW1 and PW5 in their abdomen, for which an offence under section 307 IPC and 326 IPC was found to be proved. Full stop. Consequently, the appellant was convicted and sentenced accordingly under section 307 and 326 IPC. Full stop. Next paragraph. The evidence of PW1 is to the effect that her uncle, bracket, the appellant, bracket close, threatened her that he would send PW1 to her father and that he would kill her. First step. The appellant entered her residence with a knife in hand and stabbed her on her abdomen while she was lying on the bench. As the appellant pointed the knife towards her neck, she grabbed hold of the sharp side of the knife with her right hand, due to which there was injury to her right hand. However, there was a simple slice injury caused to her neck by the appellant's knife. The evidence of PW2 and 3, who are the members of an NGO, is to the effect that they were seizure witnesses to the seizure of the knife, bracket, seizure of the weapon, bracket close, kitchen knife, which had been used by the appellant for stabbing PW1 and PW5. Next paragraph. PW4 is the friend of PW1 who witnessed PW1 being stabbed by the appellant. She stated that she saw the entire incident. First of all, however, she was frozen in fear and stood in a corner as she was afraid that the appellant would stab her too. She also saw the appellant, She also stated that she knocked on the bedroom door and told PW1 to open the door, saying that it was safe to do so. First of all. The evidence of PW5 is to the effect that the appellant was his elder son and that he had been addicted to drugs and alcohol and used to create trouble in their family. on 20/08/23. PW5 stated that he heard PW1, no, he heard the appellant shouting against PW1, stating that he would send PW1 to her father and that he would kill her. PW5 then interfered and told the appellant to calm down and not to make so much noise. To calm down, as he had caused damage to many household furniture. The appellant then went to the first floor with a knife and stabbed PW1 in her abdomen. He then proceeded towards the residence of PW1, who was on the first floor. PW5 then grabbed the appellant out and pulled him away from PW1 after he stabbed her on her abdomen. And while the appellant intended to stab PW1 in her neck with the knife, PW1 then ran away to her bedroom with severe injury. PW5 then stated that the appellant then stabbed him on the left side of his abdomen by using the same knife. The PW5 then pushed away the appellant. Next para. The evidence of the medical doctor who attended upon the two victims is to the effect that they had been stabbed in their abdomen. The evidence of PW7, who is the investigating officer, is that he had been asked to investigate the case and that his investigation showed that the appellant had stabbed PW1 and PW5. He arrested the appellant and after completing the investigation submitted the charge sheet. The question, no, the appellant's answer to question number 2, 3, 8 and 16 are as follows. And the last sentence. The appellant's answers. So question, the answer. These are in page 6, 7, page 5, 6 and 8. Page 5, 6, 8 and 10. Okay? Next. As can be seen from the deposition of the witnesses, injured witnesses, and the answers given by the appellant in his examination under section 313, there is no doubt that the appellant had stabbed PW 1 and 5 in their abdomen. There is no whisper made by the appellant that a fabricated case had been made by PW 1 and 5 against him. First, the question of whether the appellant had the intention to kill the victims is clearly seen from, is clearly proven by, is clearly to the positive, is clearly to the is answered positively due to the fact that the appellant had shouted at his niece saying that he would send her to her father by killing her. Full stop. In the case of, next one, State of Uttar Pradesh versus Naresh and others, 2011, 4 SCC 324. The Supreme Court has held that the statement of an injured witness is generally considered to be very reliable, and it is unlikely that he would spare the actual assailant in order to falsely implicate someone else. The testimony of an injured witness has its own relevancy and efficacy, as he has sustained injuries at the time and place of occurrence. The Supreme Court further held that the testimony of an injured witness is accorded a special status in law. In the present case, we do not have any reason, this court does not have any reason to doubt the evidence of PW 1 and 5. Who have stated that the appellant had stabbed them. Full stop. Next paragraph. The next question to be decided is whether the fact of this is to be decided is whether the appellant, who was supposedly intoxicated, could be given the benefit provided under Section 86 IPC, which is as follows. Take it down, Section 86, okay? Next paragraph. The appellant not having made any claim that he had been administered the intoxicant, which made him intoxicated, without his knowledge or against his will. It would have to be the act of the appellant would have to be taken to be done with the knowledge of a person who has not been intoxicated. As such, Section 86 IPC is not attracted to the facts of this case. Next paragraph. Where is that citation? That intoxication to 2023. 2023. 2023. Library, you ask the library. In dash versus dash. Take it down. Print it out, tell them to print out. In dash versus dash, reported in 2023 SEC Online SC 1491, the Supreme Court has held on dash. Okay, next. On considering all the above facts, we do not find any ground to interfere with the, on considering all the above facts, we find that there had been an intention to kill PW1 and that the provisions of section 307 and 326 have been proved by the prosecution beyond all reasonable doubt. Accordingly, in view of the above facts, we do not find any reason to interfere with the impugned judgment and order passed by the lower trial court. The appeal is accordingly dismissed. Send back the TCR. Next, in appreciation of the assistance provided by the learned amicus curiae, his fee should be paid by the legal service authority as per norms. I accordingly, and that's all. Okay. Top.
Obliged.
Item number 2.
Please, Your Lordship. My Lord, this is a case pertaining to section...
The other side is not prepared. The other side is, who's the counsel?
My Lord, Miss Mary, if it can be taken up tomorrow, I'll go through the briefs, ma'am.
Miss Mary is not here.
I think she has submitted her
Letter, yes,
my
leave
Lord.
of absence is submitted.
I forced her to do one. Second one might be too much for her, because this is slightly technical.
Yeah, in NDPS.
Now, what happened to the store owner?
My Lord, there are one accused, one co-accused. He passed away in Central Jail.
Oh, the store owner passed away?
Ming Thang Vuta.
Huh?
Ming Thang Vuta.
The one who had the shop passed away?
Yes, ma'am.
Oh, okay.
So, he passed away in the Central Jail after passing of this impugned judgment and order.
Okay, after passing of the...
Yes, my Lord.
He was also convicted?
Yes, my Lord.
So, 2 convictions?
2 convictions, and the other person is the present one.
But you have not denied the fact that you were carrying the thing, the field.
Correct.
The only thing is that you said that you were asked to deliver that
Yes,
the
my lord.
consignment.
There are several lapses, procedural lapses.
No, but then
Yes,
at the end of the day, you have not denied the fact
Yes, my lord.
that
Now,
you were carrying it.
he was carrying. Whether that was conscious or unconscious is a different.
So what to do?
My lord, I am ready, but if the opposing counsel is not ready, I think we have to adjourn the matter.
Yes, right. On the prayer for adjournment made on behalf of the learned APP, Miss Mary L. Khiante. List the matter when?
My Lord,
Let it be on a fixed date, my lord.
I'll give a date, any date.
27th of March.
intinya tungkar ni 27 tu.
No, 27 is too short. Friday?
It's
No,
Friday.
no, Friday no.
On Monday?
I will not take long here is Friday.
Then let it be listed after 2 weeks, my lord.
After a week. Yes, after.
9th of April.
All right.
9 of April.
So we'll meet at 2. Madam, you're ready, I hope.
Commission, item number 9.
Yes.
May I please, Your Lordship?
So first of all, just tell me the facts of the case. You were doing construction work over road.
Yes. For
Then-
Thongkalong to Long Masu.
Huh?
For Thongkalong to Long Masu.
So then the contract got terminated or no?
No, the contract was continued.
concluded.
Yes,
Contract
it
was concluded. And
Rollbook Lungtiang was terminated. That
Huh?
is number 5.
no, that's different.
Yes.
So this item, this
First one.
3 of 25, this road was completed, but you all had a problem with the bills.
Yes. Disputes
Your
arose. Yes.
claims were not fully paid up, correct?
Correct.
So then you made a claim, you made 13 claims, or how many claims did you make before the
Yes.
arbitrator?
We made 13 claims.
And all 13 claims were rejected? No.
No. 1, 5, 7, 8, 9 were rejected.
1, 5, 7, 8, 9 were rejected.
Yes.
And so you made a claim against these. You went in arbitration against these
Yes.
claims, correct?
Yes.
So out of 13, these 1, 5, 7. And you filed a writ petition first because you filed a writ petition for, how did you go to arbitration?
Oh, we went for appointment of arbitrator.
Under
Justice
Section
Nelson
11.
Silo appointed the arbitrator.
Under section 11.
Yes, under section 11.
So appointed the arbitrator, but you must have
Justice-
filed a WPC earlier.
Yeah. Yes, Your
What was the WPC number?
I will have to check, Your Lordship.
So
with regard to the
WPC, so
number. It was not
and
filed
what
by
was
me.
the order? What was the order dated? Justice Nelson.
30th to 2020.
Huh? No. 30th
It was in 2020 the arbitrator was appointed.
by the High Court.
Yes.
Is it?
1 second.
I doubt.
12/3/2020, Your Lordship.
12/3/20. And WPC number?
In arbitration petition number 4 of 2019.
Arbitration petition number 4 of 19.
Yes.
Then you all went to arbitration. And
Yes.
and before the arbitrator, what was the arbitration case number?
It was 4 of 2020.
Okay. Arbitration petition 4 of 19 was before the High Court.
Guwahati High Court, Aizawl Bench, Justice Nelson Silo appointed Justice B.P. Katake, retired Justice B.P. Katake.
And the arbitration case before the thing was 4 of 2020.
Yes.
Okay. Arbitration proceeding.
Yes, arbitration proceeding number 4 of 2020.
Okay. Then 4 of 2020, it rejected your claims.
Yes, primary claims were rejected.
Primary claims were rejected. And your case is that the documents
Yes.
were not gone into by the arbitrator.
Yes.
Correct?
We let primary evidence, that is documentary evidence, which was not looked into by the arbitrator.
And then you went in appeal under section 34.
Yes, challenge to arbitration award under 34 District Court.
And what was the case number? Arbitration appeal or what? Arbitration case number.
That was arbitration case number 1 of 2022.
2022 or 23?
2022, Your Lordship.
Let us see where is it? Arbitration case number 1 of 23, madam.
Oh, 1 of 23, Your Lordship.
Why you give me wrong number? Then, so that is your basic case. Now,
Yes.
now
In 2022 also it was filed, and Justice, Your Lordship only looked into the appeal, and then it went back to High Court, to the District Court again. So that is why I was saying 2022.
Okay. No, so
that was in between.
So it went back again.
Yes, it went back to the, Your Lordship only sent it back to the District Court
For what?
to look into the issue of severability and whether the claims which have been rejected can be set aside or not.
Okay, severability.
Yes.
Okay. So that was in which case?
That was in arbitration case number 1 of 2022.
1 of 2022.
Yes.
So it was disposed of while order dated? Is it here? Is it part of your records?
Yes, it is part of the records.
Page?
Page 1G, if your lordship would look into.
Huh?
Page 1G, your lordship, that is page 8 of 55, the certified copy of the arbitration, the district court, which has been passed. 1G, your lordship.
This order is not the order of arbitration 1 of 2022 is not a part of the record.
No, it's not part of the record. The dates are mentioned here. In
Page
number 8.
Page
8 of 55.
8 of 55.
The judgment which has been passed by the district court, Honorable District Court, by Mrs. Helen, Honorable Mrs. Helen.
Three of 23.
Yes, your lordship, that is the appeal which was before your lordship, Justice.
Then you said it's 1 of 22.
That is before district court, your lordship, the 34, which was dismissed by an order dated 11/8/2022.
Okay. So first you went in arbitration appeal number 1 of 2022 against the order of the
arbitrator. Yes, your lordship.
So this was dismissed.
Yes, this was dismissed. Without me being present, the matter was dismissed.
Dismissed dismissed ex parte.
Yes.
No notice.
No, nothing. The matter was not only heard. It was not heard. It was disposed of.
So then it went up before this court.
This court, a wide arbitration appeal number 3 of 2023. And your lordship disposed the order, wide dated.
But out here it talks only of 1578, doesn't talk about 9.
Your lordship, pardon?
In page 8 of 55,
Yes.
at para 7, you see the quoted paragraph.
Yes, being aggrieved by the said order.
Yes, it come down to the bottom part, 6th line from the bottom. It talks of rejection of claims of 1, 5, 7 and 8. Doesn't talk about 9.
Yes, your lordship. Not 9. That's
Then
5, 7, 8.
So only 1, 5, 7, 8 was rejected, is it?
Yes, your lordship.
Only 1, 5, 7, 8 was rejected.
Yes, your lordship.
Not 9. Because
Not 9.
earlier you had said 9 was rejected also.
Okay.
Huh?
I apologize, your lordship.
Oh, you give me the right facts. No, you give me.
Yes, 9, 10 were accepted. 11 was also accepted. 12.
No, what about 9? 9 was accepted
Yes,
also.
9 was accepted.
So only
9 and
4,
10 are together.
So only 4 claims were rejected.
Yes, 9 and 10 were together.
So this, okay, so that's all. Now, yes, anything?
Yes, I would like to put forward my arguments.
What? Tell me.
Okay. So at the very outset, Your Lordship, it is submitted that the present appeal does not seek any reappreciation of evidence. The claimant primarily relied on documentary evidence, that is the primary source of evidence. Now the award rejects the claimant's documents on the ground of further proof, that is denial of contents, despite that being only evasive denial, yet relies on an untested document of the respondent. This inconsistent application of the standards and absence of reasons goes to the root of the award and constitutes patent illegality, Your Lordship. So the challenge is confined to the patent legality, going to the root of the arbitral reasoning. All right. So if Your Lordship would look into the arbitral award, which is...
Can we go into that? Can we go into those issues?
Yes, Your
in this
Lordship, if
appeal?
material evidence is overlooked, if any document is relied upon which is not, a copy has not been given to the claimant, it can be relied upon. There is a judgment also to support the same, Your Lordship, which I will be providing to this Honorable Court. If Your Lordship can come to page 85. Of the arbitral award.
Yes.
Page number 85, that is page 5161. In the first portion, it is written, in none of the said communications...
Page 85?
Yes, Your Lordship.
85
page
is here, para 113 is here, para 114 is here.
Yes, para 113 and from para 112, the second last portion, Your Lordship.
Yes.
Yes. In none of the said communication, the respondents have admitted performing of the work worth rupees 12 crores 25 lakh 17,638, which was not paid to the claimant. The respondents, on the other hand, vide letter dated 24/2/2020, have denied the claim of the claimant. So this is the document which has been relied upon by the learned arbitrator, Your Lordship. Also, the district court, in page number 2, Roman I, 15, if Your Lordship would come into page 51 or 55.
Yes.
Para 13.17.
Yes.
In the case at hand, the learned arbitrator observed that none of the communications referred herein, the respondents have admitted that petitioner performed work so and so, which has to be paid by them, and vide letter dated 24/2/2020 made specific denial of the claim of the claimant, meaning thereby that the documents were not admitted, and as such the burden lies on the claimant petitioner to prove the work done by them to justify their claim. Now, Your Lordship, I would like to rely on this judgment by Delhi High Court in Delhi Airport Metro Express Private Limited. If Your Lordship would come to page 12.
Para?
Para 25.
Yes.
Patent illegality should be illegality which goes to root of the matter, if Your Lordship has reached the relevant portion.
Yes.
So in para 25, it talks what is patent illegality basically. So I would go to the last line, I would start from and then I would go to page 13, an arbitral award stating no reasons for its findings would make itself susceptible to challenge on this account. The conclusions of the arbitrator, which are based on no evidence or have been arrived at ignoring vital evidence, are perverse and can be set aside on this ground. Also, consideration of documents which are not supplied to the other party is a facet of perversity falling within the expression of patent illegality, Your Lordship.
Out here it has been supplied.
I beg your pardon, Your Lordship.
Out here, it talks of consideration of documents which are not supplied.
Yes, this document has not been
Okay.
supplied to us.
Which document?
This letter dated 24/20/20, based on which the arbitrator gave the judgment. This has not been supplied to us, Your Lordship. You can, Your Lordship can kindly look.
Where is this averment made in your petition? Where is this averment made in your petition that this document has not been supplied to you?
Well, this has been put forward before the district court, Your Lordship, and based
you
on
have-
whatever facts have come into my notice, I am putting forward before this honourable tribunal.
No,
There is no bar on putting forward the pleadings, Your Lordship.
you can only make submissions within your pleadings, not beyond your pleadings.
Your Lordship, when this has come into light, when I have found it out, I can put forward this
No,
pleading. There is no such denial on that.
sorry. No, you cannot. You can always find new facts all the time. You cannot change your stand all the time.
My stance is still the same. Ki if their documents are relied upon without giving us a copy,
Your basic stand is that your documents have not been considered. That's all.
yes.
Not beyond that. Anything else?
Your Lordship may kindly still consider this fact that this document has not been given to us. In the statement of admission and denial also, this document was not addressed to us. We have clearly written, in the statement of admission and denial also, we have not put forward any of the documents, Your Lordship. This document has not been given to us. So there has been no record of it. I have searched, so there is no record of this document being received by the claimant.
No, you cannot go beyond your pleadings, madam. We cannot allow that, not in a Section 37 appeal.
But Your
Sorry.
Lordship,
No,
when
no,
something has come to the light of the
not in a Section 37 appeal.
claimant, that can be put forward.
Huh?
When something has come into the light of the claimant, it can be put
No,
forward. Because both the arbitrator and district court based their judgment on this, Your Lordship.
Any other thing? Any other point? That's all?
I do have points, but I don't know if this Lordship will consider. I had all the judgments with regard to it.
No, only with regard to, you see, your entire case is that your documents have not been, your documents have been, huh?
It is bare, simple, evasive denial, Your Lordship. So if Your Lordship wants me to just stick to that, let me put forward.
Naturally, well, you cannot go beyond your pleadings, madam. We cannot hear you beyond your pleadings. Otherwise, it will be a never-ending case.
All right, so let me just.
Every day
stick
you'll get new facts to go into.
So then where is the opportunity being granted, whether before the arbitrator or before the honorable tribunal? Because
I think I've heard. This is enough. I think. Then
All right,
what about
so-
this is I think I've heard enough of it.
So let us go into the evasive portion, Your Lordship. I would just make a small submission on that. That's
Okay.
it.
Which evasive portion?
All the contents which have been denied, there has not been any reasoning with regard to it. It's just evasive denial, Your Lordship, with regard to the contents. The arbitrator, Your Lordship, should have looked into my documents based on the corroborative evidences which I have put forward, or supporting evidences, or supporting circumstances. That was not looked into. Vital evidence, if it is ignored by the learned arbitrator, it can be interfered with by the court, Your Lordship. So their monthly progress report itself shows that we had executed the work. So that document also was not looked into by the learned arbitrator. Now coming to the evasive and unsupportive denials, the denial of the claimant's documents is evasive and unsupported. If you look into Order 11 and Rule 4 of CPC, a bare denial without reasons does not amount to a valid denial, and documents may be treated as admitted in absence of a specific rebuttal. So the burden of proof shifts on them. There was no rebuttal on their part with regard to the denials, Your Lordship. So the documents ought to have been looked into. The rejection is also based on the erroneous legal approach in absence of oral evidence, that without oral evidence it becomes fatal. This is incorrect, because documentary evidence, particularly when unrebutted or specifically denied, cannot be disregarded on this ground, Your Lordship, just for the want of it. And it was only an option given to the claimant whether they want to adduce oral evidence or not. If Your Lordship will look into para 8 of the award, it was an option given whether the parties want to adduce oral evidence or not. The documentary evidence, which is primary evidence, was supported the claim enough of the claimant. So therefore, he went and said, we would rely on the documentary evidence. And that's it, Your Lordship. Since Your Lordship wants me to restrict only to the issue of documentary evidence.
That was your case. You cannot change your case just because a new day has dawned.
Well, that is the only document relied upon by the arbitrator, and he has... Okay. I think there are two standards which have been used by the learned arbitrator. If the arbitrator is setting a procedure, okay, fine, we didn't give lead oral evidence, we relied on documentary evidence. The opposite party also made evasive denials. They did not give any specific reasons for it. And the document, which I have not even received by the claimant, was relied upon by the arbitrator. So that test of inconsistency in the approach, if the procedure is set, it has to be same for both the parties. So the procedure was not same for both the parties, Your Lordship. So these defects, so there is absence of reasons. Nothing is corroborated. These are cumulative conclusions. No reasons are given with regards to the claims. So, and the failure to deal with the documents in the face of evasive denial goes to the root of decision-making process and constitutes patent illegality. So, Your Lordship, the issue herein, in my humble submission, is not the weight of evidence, but that relevant evidence is not considered at all, while irrelevant material is relied upon, squarely attracting the perversity standards warranting interference of this honorable court under 37, Your Lordship.
That's all?
Yes, I would not add
Okay,
anything.
yes, madam, anything?
Your Lordship, at this stage, I have been instructed on behalf of Mrs. Mary that they have received pairwise comments. However,
No, what pairwise? This is an appeal. Where is the question of pairwise comments, madam? This is the second appeal.
Yes, Your Lordship.
There is no question of pairwise comments. There is no question of... my God. You all should have some idea. In appeal, there is no question of submitting documents one after the other. Okay, then what about the second case, madam?
It's the same, Your Lordship. I would just rely on one judgment if Your
No,
Lordship...
out here, what has happened? Just tell me the facts again.
Yes.
Out here, what was it was a contract work. For which contract work? Same contract work? Huh? Roll book to Lung Tiang. Okay. So it was terminated?
Yes.
When was it terminated? It was terminated, then what happened?
Then the matter went to Guwahati High Court for appointment of arbitrator. The arbitrator held a determination.
What was the arbitration case number?
The arbitration case number is 5 of arbitration proceeding number 5 of 2020, Your Lordship.
That is before the arbitrator.
Yes.
But the Guwahati High Court order 12/3/22 was passed in which case? You don't know. So then this was on what? It was your contract was terminated.
Yes, the contract was terminated, disputes arose and claims, we had certain claims. We had raised
Terminated on what ground?
52 of general conditions of contract. 52 of general conditions of contract.
What does 52 talk of?
52 talks about non-completion of work during the specified time limit.
And the arbitration proceeding ended with what? Any claims being allowed? Some claims being allowed.
Some claims being allowed.
Where is the arbitration award? Page?
54, Your Lordship.
Page?
Page 34, Your Lordship.
No, what is the, how many claims did you make?
The claims were 13, Your Lordship.
Again 13. 13 claims were made, how many allowed?
Except for 7, 8, 9, 10, the others were allowed, Your Lordship.
7, 8, 9, 10. Others were allowed.
Yes. These were the primary claims.
7, 8, 9, 10 not allowed. Okay. And they also made counter claims?
Yes.
And their counter claims were allowed or not?
No, the counterclaims were not allowed.
And what about in the earlier case, was there any counter claims made?
Yes, Your Lordship. Both the cases, counterclaims were made.
Did they allow any of the counter claims?
No, Your Lordship.
No, in the earlier case also. So you went against the 7, 8, 9, 10.
Yes.
It was rejected.
Yes, those were the primary.
On the same ground. On the same.
Same ground.
And you all have not approached this court before, under 37, unlike the earlier case.
No, we approached this court.
Earlier?
Yes.
For what?
Because my 34 court did not hear my case, so that is why.
Okay, same thing, same.
Yes, none of the claims were discussed. Only the thing was that the 34 court has not listened.
Where is that page? That's again in the arbitrator's proceeding, it will be reflected.
Yes, Your Lordship.
Page?
Arbitrators proceeding.
Not proceeding or in the order, award?
Award. The award is in page 34, Your Lordship. The award starts from 34.
Where does it talk of the your earlier case before this court?
No, Your Lordship. This award does not reflect any of that, Your Lordship.
So what is the earlier case that you had, where is the earlier judgment order of this court? It's not here.
The order passed by this honorable court with regard to the appeal 37, that is not annexed in this, Your Lordship.
What is this? What was the earlier case number?
That was arbitration appeal 2 and 3 of 2023, Your Lordship.
Arbitration appeal
3 and number 2 of 2023.
2 of 2023. In the earlier case, it was sent back to the arbitrator, correct?
No, Your Lordship.
It was sent back to the appellate court. Here also it was sent back to the appellate court.
It was sent back to the
Appellate
district court. Yes.
District court.
None of the claims or anything was discussed in the first appeal, Your Lordship. Only the issue of severability was discussed.
And get the records of arbitration 2 of 2023 and 3 of 2023. Disposed of. Arbitration appeal 2 of 2023 and 3 of 2023. 3 of 2023. Okay. Okay, right. Heard Ms. S. Bhattacharya, learned counsel for the appellant, as well as Ms. Lal Nunri for the state of Mizoram. I'll dispose of the matter. Let me see how it goes. Disposed, huh? Disposed.
If Your Lordship would allow, I would just like to put forward this judgment with regard to, since you're just relying on oral evidence. Only this paragraph I'll just read out quickly, Your Lordship. I won't take much time. Para 4. Page 2, Your Lordship. Para
Yes.
4.
Para 2.
Page 2, para 4.
Para 4, yes.
In my opinion, to hold that a document is not admissible for proof of its contents unless the writer is called is to denude documentary evidence of all its value and is clearly contrary to the express statutory provisions to be found in the Evidence Act, to which I will presently refer. Documentary evidence becomes meaningless if the writer has to be called in every case to give oral evidence of its contents. If that were the position, it would mean in the ultimate analysis, all evidence must be oral, and that oral evidence would virtually be the only kind of evidence recognized in law. I would come to the last 3 lines. Section 59 of the said Act enacts that all facts except the contents of the documents may be proved by oral evidence. May, Your Lordship. It does not say shall be proved by oral evidence. So it's a discretion, Your Lordship. May kindly note this fact. This provision would clearly indicate that to prove the contents of a document by means of oral evidence would be in violation of that section. And the section 91 expressly prohibits that being done in the case of contracts, grants, or dispositions of properties which have been effected in writing. Your Lordship may look into page number 3, the last 4 lines. legal propositions such as that document of proof does not amount to proof of truth or the correctness of its contents, or that the proof of the document is no guarantee of the truth of correctness of its contents, are, in my opinion, entirely out of place in regard to the question of admissibility of documentary evidence. The question that arises at this stage only is, on execution being proved, can the document be used for the purposes of its contents? The answer must be yes, to the same extent as the oral evidence to that effect. The object of proving the document is no doubt to prove the truth or correctness of those contents. But whether it amounts to proof of the truth or correctness of the documents is purely the question of probative value and not admissibility. That's it, Your Lordship. I would rely on this.
Okay. दे देगा हाँ मेरा रूम में
Next.